Welcome to another episode of Everything You Ever Wanted to Know About Lawyers But Were Afraid to Ask. Hi, it's Ron Coleman again with the second in my series of videos about the legal profession, or at least what I know about the legal profession, which I'm making because people tell me they're interested in it and that they think they might want to hear about it. We'll see. In the last video, which was the first in this series, I talked a little bit about how I found myself in law school and how I became a litigator, and but the differences between corporate litigators and trial lawyers. It's a little bit of a false distinction because there are many people who do cross that line, such as myself. On the other hand, as a general rule, people in corporate law firms, especially in major cities and major firms, frequently have little or no actual trial experience. In fact, there are probably a lot of them who have done more work arguing appeals than trying cases before judges or juries, separate and apart from those who actually focus entirely on appellate practice, which is a very interesting subsection of the bar. I want to talk about corporate litigation today and why it's so important and so expensive and so problematic. My first job out of law school, I should make it clear that I graduated from Northwestern in 1988, but I didn't start working until 1990. In the 2 years between finishing law school and starting work as a lawyer, I went back to school. I actually attended a series of yeshivas, or Jewish learning academies focusing on Talmud study. That's not for this video. Maybe I'll talk about it some other time. But I was deferred from from the job that I accepted when I was in law school, where I had been a summer associate my second year after law school, a firm that was at the time known as K. Scholler, Fierman, Hayes, and Handler. More recently, it became known as K. Scholler, and then it became the New York office of another firm that considers me an alumnus, even though I never had anything to do with that firm, by virtue of my past association with K. Scholler. Now, that association was a very short one, because despite my obvious brilliance, or perhaps because of it, I was a very unsatisfactory associate for a 300 lawyer firm, which in those days was a large firm. I mentioned in the first video that I didn't come from a professional background, and that's not an excuse, because lots of people who didn't come from professional backgrounds get it, and they get it very quickly. I wasn't one of those people, however. I didn't really understand the ethos of being a very junior, first-year corporate lawyer, which is that your job is to stay busy as crazy and to bill as much time as possible. That's how the law firm makes money. Your job is not to finish the assignment and then go home, but to basically to spend as much time on the assignment as is reasonably possible and doing it right. And I'm not talking about stealing from the client, but making sure that you're very, very, very thorough and that you account for every single minute of your time, which is a very broad concept as well in this environment. Every minute of your time. If you're in the office from 9:30, which is the traditional, going back to probably the banking sector, which the major firms historically service, but in New York, the custom was, in the 80s anyway, that starting time for major law firms was officially 9:30. So you get to the office at 9:30, and if you were very, very busy, which you were expected to be, then you would be staying past dinner time, 8:30, 9:30. I'm not talking about what they call the sweatshop, but a busy, large, major law firm. So that would be 11 hours in the office, right? So a lot of people managed to bill 11 hours. They were in the office 11 hours, and they billed 11 hours. They ate at their desks. They took calls. This is before email, right? This is before texting. This is before the internet. So you really didn't have much else to do at your desk except maybe take phone calls, talk to people, or talk to people away from your desk, get the old water cooler, or go to the copy machine. If you were on a big project, such as a document review project, and I'm going to talk about that in a minute, people would typically just bill for the entire day, minus perhaps lunch, half an hour. And that's how you racked up 18, 1900, 2000, 2100 hours a year by getting onto these big projects and billing your whole day to them. I wasn't very good at that. I was a little bit naive. I would only bill the time I was actually working. But that was my mistake. I didn't get it, how the game was played. In any event, what do you do when you get to one of these major firms? So again, I'm going to talk about my experience as a litigator. I was in the So at K. Scholler, the department was called Litigation and Antitrust. The firm, in fact, had flourished from fairly humble beginnings into a very large firm on the back of doing antitrust work for the Texas company, which you would know as Texaco. Antitrust work. There was a lot of antitrust involving the oil companies in the 70s and the 80s. Less so in the 80s, but it was a lot of work. K. Scholler, because of the outstanding antitrust expertise that the firm had in the person of Professor Handler, K. Scholler, Fearman, Hayes, and Handler. Professor Handler was an authority on antitrust who was the name partner at K. Scholler, and had brought a lot of very important work to the firm in antitrust, and the firm was involved in the IBM, I think, antitrust litigation. A lot of big antitrust cases did involve K. Scholler. At the time, it didn't have very substantial. It later became known for other things, especially when antitrust, even though the statute remained in place, the government basically just stopped enforcing it for various reasons: political, legal, jurisprudential. But in any event, antitrust became less important. But that was the name of the department we were in. I came to K. Scholler, therefore, in the fall of 1990, after my 2 years in yeshiva. And the main thing a junior litigation associate does, or at least did in those days, but I think it's still the same, talking to people whose kids I know have gone into these sorts of firms, is research and writing, such as finding out the answer to a legal question in order to help somebody write a brief, or eventually, within a couple of months, writing brief points yourself. This is something that you are trained to do in law school. Legal writing is one of the most important things that you learn to do. So legal research and writing, and document review. Now, in many respects, the profession has changed, and junior associates in many firms, including the largest firms, do not do document review. There are separate cadres of document review lawyers who are considered to be a sort of lower rank of professional. They're typically not on the career track of associate to partner, or at least the notional career track of associate to partner. What happened was that major companies that were paying for massive document review, and I'm going to tell you what document review means, and that'll keep us busy through the end of this segment. They realized that there's no reason on earth to pay top people from top schools who were getting top salaries in top law firms to go through hundreds, thousands, tens of thousands, or millions of documents in closed conference rooms for 10, 12, 14 hours a day, looking for the word banana or the word oil rig in documents. There never was a reason for that, but eventually it took a while for the companies to figure it out. It also took a while for technology to figure it out. Now all documents are scanned, OCR'd, and reviewed using artificial intelligence in any kind of major document review case. But in the 80s, and certainly in the 70s, document review was how you paid your dues in a major law firm litigation department, and it was not a lot of fun. I mean, there was a social aspect to it because you'd be in this conference room with 5, 6, or more other young, bright associates, and maybe that somebody would bring in a boombox and you would listen to music and talk about current events while doing the fairly mindless task of document review, going through boxes and boxes and boxes and boxes of printed documents. Remember, this is before the digital age. Printed documents looking for certain keywords or determining if the documents were non-responsive to the document request. I haven't even explained what a document request is. I'll have to do that in the next segment. But it's fair to say that in general, in civil litigation in the United States, each side is entitled to know what the other side has in his or in its files that could be relevant evidence to the case. So if it's a very big case involving a lot of transactions or a lot of people or a very big company where a lot of memoranda and correspondence and operational documents are generated, then all the files have to be opened up. They have to be copied and distributed for review so the attorneys can decide what's relevant to the case, what the other side has or has not asked for, what are documents that we're going to want to use as evidence in our case, or either as defense or to prosecute the case or counterclaims. A lot of the documents are copies. You have to determine whether something is really just a duplicate or whether there's marginalia that perhaps would distinguish it and could be of evidentiary significance in the case. This is the kind of thing that makes you quit working as a lawyer in a big law firm. If you are restless and you think of yourself as particularly intelligent and you aren't very good at paying dues. And, I'll tell you, if you take anything else away from this, if you're going to law school, considering it, or you know someone who is, at this juncture, I'll remind you once again, don't be like Ron Coleman. Learn how to pay your dues. There's nothing more important in the profession than paying dues. I'm not saying to be a schmuck about it. I had trouble paying my dues, and I crapped out of it. I lasted about a year at K-Scholler, and we'll talk about document review and discovery in the next segment. Thanks a lot. Thank you for watching and for your patience as I work out how I'm going to do this on YouTube. If you want to see the next segment where we'll explain a little bit more about what I talked about today, subscribe and you'll know when it's uploaded. I appreciate your interest.